With Melendez v. SiriusXM Radio, 211769.
Good morning, Your Honor.
Hold on a second, Mr. Puppet.
Thank you.
Okay, you can go.
Good morning, Your Honors. I represent the appellant, John Melendez, who's also known by his stage name Stuttering John, a celebrity and former writer and on-air performer for the Howard Stern Show for 16 years. He has brought a case in the Southern District on two claims, both under California's right of publicity. The main question on appeal, as briefed, is basically, can a California right of publicity claim ever survive copyright preemption as pled here? And is there a pathway for celebrities who work on shows that are themselves copyrighted to obtain compensation for the continued unauthorized use of their identity, their persona, for commercial gain? We say yes, and our First Amendment complaint, following the guidance of Judge LaValle for this court in Jackson, we believe does just that and avoids any preemption under Section 301 of the Copyright Act.
Mr. Poptok, let me just see if we can agree on where the preemption line is before we get to what you pled.
Yes, sir.
So if there's a clip of an archived show, 10 seconds of a clip, and it says, listen, this is on the Howard Stern channel, and it says, listen to this at 8 a.m. every day, you would agree that's preempted, right?
I would think that we're not, I agree with you, Your Honor, that we're
All
not
right.
trying to stop the playing of the Howard Stern Show or clips of the Howard Stern Show.
Or an advertisement on that channel of the Howard Stern Show, right? Listen at 8 a.m. to archived, with a 10-second clip, including your client. That would be preempted, right?
I wouldn't go that far, even under Jackson. I think that if they're playing my client's voice to advertise for that show,
They have the copyright for the show and they can't advertise for it. There's no case that would suggest you can't use the copyrighted material to advertise. Cases have said the opposite, that an advertisement that includes the copyrighted material is fine. You have to be able, one court said it would be illogical not to allow them to advertise the very copyrighted material they have, right?
yeah, it's how they're doing it.
Well, I just gave you how they're doing it. They're just playing a clip for 10 seconds.
On the show itself?
Yeah, on the channel itself, saying listen at 8 a.m. to an archived show.
Yeah, I think that's okay
All
under
right.
Jackson. But
If you do it on another channel, let's say it's a random channel, and they say on channel, whatever it is, 101, at 8 a.m. you can listen to the Howard Stern archives, but it's a different channel on Sirius. That's got to be okay, right?
Well, no, I don't think so. I think under Jackson and its progeny and other case law, I think there has to be a pathway. And
So if I have a movie theater, and I show a preview, I have the license to show all the 6 movies in a multiplex. If I show a preview of the movie in one theater saying, you can go watch this in the other theater, you're telling me that you could have a right to publicity claim because I showed a preview in one of my other theaters?
if you're using my client's persona and celebrity and attributes, which are not a work that can be copyrighted in order
I'm using
to
a
gain
clip.
commercial
I'm
advantage.
using a clip of the copyrighted material.
It's always going to be a clip, Your Honor. It's always going to be Stuttering John's voice.
So I have the
on show.
copyright for this movie, and I can't tell anybody I have it, that they should come and see it. That's what you're essentially saying. Otherwise, I'm going to have a right to publicity claim brought against me as the owner of the movie theater.
I think the answer to the question that I find from Jackson is that there is a line, and that we believe they've crossed it by taking and extracting, this is as alleged, extracting his persona, his attributes, which even though they're embedded within a copyrightable work.
Jackson said the opposite. Jackson said if you endorsing a new product, it gave all the cases that are cited in the briefs that when you're using the persona to endorse some other product, then it's not preempted. That's what Jackson says. Jackson, where in Jackson does it say you can't advertise your own copyrighted material?
But that's not what you're alleging that Sirius is doing, just playing the Howard Stern archive. I'm not trying to stop, let me make it clear, we're not trying to stop the Howard Stern archive from being played for the Howard Stern show in any way. It's just you can't take my client's persona.
You're saying, let me see if I can sum up what you're saying. You're saying they can't advertise for the show. They can't advertise for the show, period. Otherwise, it's a right to publicity claim that can be brought.
That's the line. You can't take my client's persona and use it for advertising for things unrelated to the Howard Stern show, which we've alleged in the complaint.
So if Spotify says, plays a clip of a Billy Joel song and says, sign up to Spotify, we have Billy Joel songs, you would say, not preempted by copyright law, right? You could sue Spotify for letting people know they have the Billy Joel song.
Well, if it's a copyright, Billy Joel would have the right to sue for infringement.
No, if they have a license, to play Billy Joel, and they have a commercial that says, sign up to Spotify, listen to Billy Joel, and you would say, no good.
It would depend on how they're using Billy Joel's persona and DNA and attributes
They're playing 5 seconds of the song.
to advertise what for.
To sign up for Spotify so you can listen to it.
I think that if he's a California resident, I think he has a California claim for right price. I don't think that's what Jackson says.
That would be that would make copyright completely irrelevant then. You would have a copyright that's useless because you couldn't advertise for it. It's like buying being a subscriber to Spotify or to Sirius. It's like having a movie ticket. It's like purchasing the ticket for the movie, and you're saying they can't advertise for you to purchase the ticket.
I don't think you can go on your social media, take my client, extract his persona, and advertise for you, either your station or for others, or more importantly, for other products to send subscribers to SiriusXM. I don't think that's...
Let's say I disagree with you.
I
All right?
understand you do.
Okay. Where in your complaint would, if that's all preempted, where in your complaint do you allege something that would not be preempted, I guess would be the question. Because all you do say in paragraph 44 is they're using it for other products, and you say, including, I think, Sirius, advertising for Sirius as a whole. So if I think that's preempted, that they're allowed to advertise for Sirius as a whole using a clip from the copyrightable material, where else in your complaint do you say something else?
The places in our complaint that we point to are in the introduction on page 2, where we talk about that they use the persona of Stuttering John in their online media and on-air advertisements to promote SiriusXM in general and other channels not related to the Howard Stern Show. We say the same thing on page 3. We say the exact same thing on page 4. We say it in paragraph 34.
But if the view is a lot of that would be preempted, you have to allege something more to show that you have a plausible, non-preempted claim.
Well, Your Honor, that would mean then the Second Circuit's position is going to be that California right of publicity is always basically preempted because they'll never...
No, you gave an example in your brief where it would be preempted. If they used your client's voice or stuttering in some way to say, sign up to Sirius in a way that suggested your client was endorsing Sirius, that certainly wouldn't be preempted. But you don't allege that.
Right, because you're right, Your Honor, because I'm alleging. I'm in the amended complaint phase. Almost every case we've been referring to is in the summary judgment or trial phase after there's been discovery. There's only so much my client and lawyers before they file can catch on the air of what they're doing. We caught a few, we put them into the pleading. We think we've stated sufficient facts to get to the discovery in this case.
You have to state a plausible claim before you get to discovery.
Which we believe we have, Your Honor.
Can I ask just a really nuts and bolts question? There's a lot of language that sort of embodies a conclusion, extracts his persona using his attributes. I want to make sure I understand the tangible underlying allegation. Is there any allegation that there was a use of anything other than an actual clip as it existed, not distorted, not edited to suggest something different?
Well, they mentioned his, so they mentioned his name, and they mentioned Stuttering John as a personality, so that's false. It's not just his voice replication.
When you say they mention his name is articulated in the context of a clip, or they say, here's a clip of Stuttering John. Give me the context of the allegation.
It's a little bit of both. It's upcoming. Here's a clip of Stuttering John. Go to channel 101, and we'll be doing, the interview that he did 10 years ago, or whatever it was, the Dacia interview that he did. Pardon me. Part of it is the mentioning of his name and using the persona for a competitive advantage or for a commercial advantage. But the identity that they're using is so important here that that's the reason that they're using it to drive revenue in a way that it goes beyond what is protected by the copyright law. But no, I'm not arguing, Your Honor, that they've created a poster or something else, like something else that wasn't from the show originally. He hasn't been on the show in 16 years. But they continue to see commercial value in exploiting his persona in order to drive people back to that channel and to other channels. It's a whole subscriber base model. Is that to your question, Your Honor?
Yeah, I mean, I guess the other thing, and I think maybe you've answered it, is you allege that it was using these to drive people to other channels, and I'm trying to understand that. I could see how advertising, putting the clips on other channels is a way of informing people who are listening to those channels that they can be driven to the 102, 101, but in what way is that advertising for the 70s music station channel?
Well, if he's advertising on a 70s music station in order to bring it back to the Howard Stern show, I would say that's an improper exploitation of that persona, even though it was in a copyrightable work. The thing that I am alleging is not copyrightable, right? But I don't currently, to answer your question, I don't currently have examples, and maybe Discovery will bear this out, of where by advertising on the 70s, there's an uptick in commercial traffic overall to the whole business model. You know, it's not just one channel. You get SiriusXM, of course, because you want 250 channels of who knows what, but 4 of them, or 3 of them being Howard Stern show. But it's sort of all as an ecosystem that works together. So I think that using it on one is not just to advertise; it inures to the benefit of the entire, channel ecosystem.
I see. I'm trying to understand how you've acknowledged that if you use the clip on the Howard Stern channel to say, hey, you can listen to this, that's probably preempted, but if you use it on another channel to say, hey, if you turn the dial, you can listen to this on the other channel, that's somehow advertising for something different.
Yeah, now you're extracting the persona of my client that's not copyrightable. You're using it for a way that was not the original way in order to go on other channels to send it back without compensation. I think that is the right of privacy either under common law or statute in California. The line, I think, has been crossed.
What is it? I just have a very fundamental question for me. I've been interested in your answers to the questions from my colleagues. What relief do you get under California law that you're not able to get if you pursue just a claim of infringement under the Copyright Act?
Yeah, he doesn't have a claim of infringement under the Copyright Act because whatever the copyright or copyrightable material is as pled, that is owned by SiriusXM or came from the.
So this is it.
Show. Yeah, this is his ability to protect his right of privacy and to either stop the continued unauthorized use without compensation.
You're seeking an injunction here, right?
An injunction, but not on the playing of the Howard Stern archive, because that sort of got misinterpreted, I think, by Judge Crowdy, with all due respect. We're not trying to stop that. They can keep playing it for as long as they like. They just need to compensate my client if they're going to do that for the uses that we're talking about.
Okay. All right. Well, I think we've got your argument well in hand, and we'll hear from the other side.
Thank you, Your Honor.
Mr. Bagdasarian. Did I pronounce that correctly?
Yes, Your Honor, thank you. May it please the court. Mark Bagdasarian on behalf of Apple SiriusXM. As the discussion just showed, merely advertising through clips of the Howard Stern show in which appellant appears does not state a claim for life publicity under California or any other law. As was pointed out here, the case law is clear on the point that merely advertising and showing his appearance based on his performance on the show is not a right publicity claim. That's a copyright claim.
Well, there are forms of advertising that might take it out of the subject matter of copyright, correct?
There could be under certain circumstances, and the parties have briefed extensive case law to this court showing the circumstances under which that scenario could play itself out. And as a general category, where you see that is in the context of, taking an attribute, as appellant said here, take his stuttering, which is what their allegation is of his persona.
I forgot to mention one thing at the very beginning, and I apologize, Mr. Poptok. When you are at the podium, you can take off your mask.
I'll do it in a moment.
Whoever's talking can take off their mask.
Thank you, Your Honor. That's actually very helpful. But the case law that's been cited to this court by both parties show the circumstances under which a right of publicity claim can be made. It is doing something, and even once we've recognized the separate and apart from his performance in the copyrighted work, in order to suggest some endorsement of a product or service. We don't have any of those allegations.
So if they played a clip and said, buy Howard Stern t-shirts, that would be a problem, that had his persona on it, right?
That's an example of something.
Or if they imitated his voice, that would be a problem, right? If they imitated his voice.
If they imitated his voice, if they did a caricature of him, if they, for example, as his opening brief says, subscribe to SiriusXM because Stuttering John wants you to, or something.
But their fundamental argument is that Sirius is a separate product, that if you advertise for Sirius, that is a separate product using his persona. What's your response to that?
But we're not using his persona. The only persona that's alleged in the complaint is...
Well, suppose you get an advertisement on regular TV that says, sign up to Sirius and you'll get to listen to the Howard Stern Show, and you played a clip from the Howard Stern Show on radio or TV.
Your Honor, that does not create a right of publicity claim. That is what the case law that you referenced earlier says specifically. It would be illogical to not permit a copyright holder or a holder of a copyrightable work to prevent them from advertising the very thing they're allowed to do. The movie analogy is a very good one. It would be like performers in a movie. Tom Cruise, take your favorite actor and saying that the copyright owner or the copyrightable work cannot advertise to people to say, hey, come see Tom Cruise in a movie. In fact, there's not even an allegation in this First Amendment complaint that even goes that far. What I heard today and what I see in the First Amendment complaint and what I saw in the briefing is just saying, hey, they advertised with his performance on the Howard Stern Show. That's it. There's nothing more than that. And we know that because what we see in the briefing is what we have called in our briefing theoretical claims, theoretical allegations, where maybe they did it this way. They could have done this. They could have done that. The problem is could-haves don't rise to the level of a plausible claim.
May I ask you something? And I understand that this is at the motion to dismiss stage and we're to review the allegations, but how is his voice used? How are these clips used? Are they used only for the Howard Stern Show on SiriusXM, or are they used in some other ways?
Based on the allegations of the complaint, they're only used for the Howard Stern. They're only used for
No,
the
in
Howard Stern.
paragraph 44, he says it's used to advertise for Sirius more generally. That was the one example he did give in the complaint, right?
Your Honor, I respectfully submit that's not an example of anything. It doesn't tell you how, where, or what it is.
My question, you don't have to answer any of these questions.
Sure.
But my question is, how in fact are they used? I mean, I understand that there are these allegations, but are they used beyond the Howard for purposes of advertising beyond the Howard Stern Show or beyond SiriusXM? I don't see how.
Your Honor, the only way I can answer that question, as far as I know, I don't even know that they advertise with clips that include the appendix. To the extent that things are advertised, because I do know SiriusXM very well, we've represented them for a long time, they advertise what's on their channels.
Yeah.
So people are made aware of the content and things that they have on their channels. And that includes, obviously, Howard Stern, who's currently on two of the channels.
So you're not even sure that they advertise generally for Sirius outside of actual people who are listening to Sirius, that they advertise more generally using the clips? You're not even aware whether that's...
I'm not aware that they're even doing that, Your Honor, and quite frankly, based on the allegations of the complaint, I'm not even sure that they're aware. You know, he's been off the show. The appellant's been off the show for 15 or 16 years. Throughout that entire period of time, including today, whatever's being broadcast on SiriusXM can be heard by anyone. It's very easy to do that, and he can't come up with one example to explain how it's being used in a way that would violate or potentially violate a right of publicity under California law. Tell me, for example, that we did, Stuttering John says, you should subscribe to SiriusXM. That said properly could give you a right of publicity claim. He can't do that. He can't claim a vacation. He can't claim some sort of voiceover, some caricature, or something like that. There's nothing separate and apart from his appearance on the show that he has alleged in the First Amendment complaint or anywhere in order to be able to make that claim. With that, Your Honor, if you have any further questions, I'm happy to answer them. Otherwise, I'll use the balance of my time.
Thank you very much.
Thank you, Your Honor.
All right, Mr. Poptok, this is your time without a mask.
Thank you, Your Honor. I appreciate that. I'll take advantage of it. And I'll make this brief. While I appreciate Your Honor's asking questions outside the record about how is Mr. Melendez's persona being exploited or used inside the channel or outside the channel, SiriusXM has the records, the databases, the archive, records of their advertising. We do not. And so we have made sufficient allegations. We don't have a heightened pleading standard under Rule 9b or any other heightened pleading
So I
standard.
just want to make
No.
totally sure that I understand.
I just want to make sure what was inside.
Oh,
and
no.
outside the record.
I asked
Yeah.
I asked a question that was designed to
Yeah.
find out what was outside of the record.
And for us, we think the allegations are sufficient to lead to the discovery to get past.
But
Of course, that's why you're here. But
these-
That's why we're here.
Go ahead.
So-
If these allegations are sufficient, doesn't that mean everybody going to get to go to summary judgment? All you have to say is they're using my persona outside the copyrighted material, period. And you're saying that's sufficiently pled to get you to summary judgment. Isn't that what you're suggesting?
Well, I'm suggesting that we've signed a pleading under Rule 11 and that we have sufficient basis to allege what we've alleged. I don't have to allege more. I don't have to put in my evidence.
All you have to allege is they're using my persona in a way that's unrelated to the copyrightable work. That's enough.
That what is being used is not either able to be copyrighted or is
Well,
outside the copyright.
this is able to be copyrighted, right? Obviously.
Well, not his personas, his attributes that go to the DNA of who John Melendez is cannot be copyrighted.
That is my fundamental question because I'm quite confused. Are these recordings not copyrighted?
They're either copyrighted or copyrighted.
Okay,
We'll
so
see that.
and they're rebroadcasting these copyrighted clips, correct?
Which they're permitted.
And they're permitted to do it, as I understand it, and I'm trying to figure out what the line is that you are asking us to draw. They're permitted to do it with respect to advertisements for the Howard Stern Show.
Well,
Yes or no?
They are, as long as they don't go too far. You
What?
can't extract.
No,
and say-
no. So stop, please. Just give me 1 second then, because then my confusion grows. So when you say that there's a line, even with respect to the company's ability to use its own copyrighted work in connection with the very show that your client was on. Is that what you're saying?
Well, I haven't alleged it here, but I could see.
What is that line?
Sorry.
What is the line? Tell me what the case law is that supports
Well, I
your
would
view.
refer us back to Jackson. I mean,
Where in Jackson does Judge Laval say anything that supports that view?
Well, I'll take it where he believes the analysis begins and ends, and I think applies here. It says, in our view, the pertinent, this is on page 41 of Judge Laval's decision. In our view, the pertinent distinction for such analysis is whether, on the one hand, the defendant's use of the work involves the plaintiff's likeness, seeks advantage for the defendant on the basis of the plaintiff's identity. That's what we've alleged. As where the plaintiff is identified in a manner that implies the plaintiff's endorsement, sponsorship, or approval, or in some cases the plaintiff's disapproval or rejection of the defendant or its products, or holds opinions favored or disfavored by the defendant. The value of what the defendant distributes lies in its reference to the identity of the plaintiff shown, what might be called identity emphasis. So if there's identity emphasis, which we've alleged, we believe that crosses a line.
Judge Laval said courts find these claims preempted if it's based upon, if they conclude the invocation of the publicity right was a pretextual justification for an effort to prevent or otherwise control the reproduction or dissemination of a copyrighted work. That's what he said. And essentially, that's what you're arguing to us, that you should be able to control their dissemination of the clips, which is a copyrightable work. The clips are copyrightable work. You're saying we should be able to control that. Isn't that what you're saying,
No,
Thomas?
they can continue to play them.
You just told me they can't play it on any other channel. They can't, all they can do is play it on the Howard Stern channel, just play the whole thing. They can't advertise with the clip.
They can't use my client's identity and his celebrity to drive traffic or to gain a commercial advantage. That's
Including the
that's-
copyrightable work itself. They can't use the copyrightable work itself.
They can't extract from the copyrightable work that which is not copyrightable, which is my client's persona.
What do you mean when you say, I don't understand what it means to extract that from the work. There's a clip, and it's copyrightable work. What is the act of extraction that you're describing?
They can't say the Stuttering John, they can't use the Stuttering John clip to advertise somewhere else to drive traffic back.
To see the
Yeah.
show that is copyrightable?
Right, to use his voice, which can't be copyrighted, even though it's in a copyrightable work. And there's tons of cases that we've cited in which the thing that is embedded within copyrightable work may not itself be subject to copyright.
Every case goes the other way on this. Every single, Jules Jordan video says you can put it on a DVD. That's preempted. The Ray versus ESPN. ESPN rebroadcasts these wrestling matches. Preempted. The Laws case. Taking a portion of a recording that they have a copyright to and putting it in another song, the Ninth Circuit said was okay. Every single case
Well, we
says...
cited a dozen cases that go in our direction.
Well, you're citing Jackson, but would you describe for me, and maybe, I think we've got your argument, but would you describe for me how we are to dissect or differentiate between the work, the reproduction or dissemination of the work itself and the persona?
How do we
Yeah, I mean, you're asking us, you're saying that so long as his persona is captured in the work, I think, then that becomes a problem.
You can extract from the copyrightable work Stuttering John as a persona and use him as an advertising shill for what you're selling.
What is it that SiriusXM should do?
They shouldn't use John Melendez's
Right,
name
that's
like this to sell
at
their
all.
product unless they pay for it
At all? Okay.
at all.
That's your bottom line,
Yeah.
and I appreciate that candor. Well, thank you very much.
Thank you, Your Honors.
Appreciate the argument. You can put back your mask, Mr. Popper,
Yes, sir.
and we'll reserve decision.